Madam, I beg to move the bill further to amend the Copyright Act 1957 as passed by the Rajya Sabha be taken into consideration. Madam, I remember when I was a young boy, one of my delights used to be to go to the cinema in the evening and watch a movie. And I used to admire the artistic quality, not just of the film, but of all those elements in the film, which provided entertainment to all of us. Over the years, of course, the nature of the film industry has changed. And now there are many more vehicles of entertainment. Apart from going to the cinema.
Honourable Member, why are you crossing? Please take your seat.
Apart from the cinema, there are other vehicles through which entertainment can reach millions and billions in the world. The Indian movie industry is popular wherever you go, anywhere in the world. People remember, if it's Russia, people still remember the song sung by Raj Kapoor, Aawara Hoon. And if I go to sometimes to the Eastern European countries, people are singing modern songs that are being sung in Hindi films today. The same situation in Egypt. There's a huge market in the United States of America. And apart from the fact that this has given impetus to artists to produce artistic works of great excellence, it has also become a great business. It's also become a great business. And with the change of technology, new avenues of business have arisen. And Madam, if you really look at the history of the copyright law, the first protection to the copyright law was given way back in 1709 by the Statute of Anne. And it's very interesting to note that even the US Constitution has a specific provision on protection to copyright, because they realize the importance of intellectual property in the artistic works that emanate from citizens who have those qualities. The point that I was making is that this is something that needs to be protected. But unfortunately, over the years, especially in the context of artists in India, the producers in this country, through an assignment, took over those rights. Under the Copyright Act, under Section 13(1)(a) of the Copyright Act, there is protection to the artistic work, whether it's a literary work or a musical work or a dramatic work or a performance. Protection is provided under the Act. And so the artist is the owner of that copyright because he creates that artistic work. But unfortunately, there was a provision in Section 17(1)(b) of the Act, under which it was said that yes, the artistic work belongs to the owner, subject to a contract to the contrary. So what used to happen is that if in a film a song was to be sung, the producer of the film would go to the artist and say, you assign your rights to me unconditionally, and you assign them forever. The result was that under the copyright law, instead of the artist, the producer became the sole owner of the copyright. And the result for that was that he produced the film, the artist got the benefit of whatever he could get in the film, but he sold those rights, of which the producer became the owner, to other mediums. He sold it to music companies, he sold it to telecom companies, and he made all the profit. He made all the profit. The result was that the poor author, the poor creator of the copyright, did not get any share of the profit. This is, according to me, a historic injustice to the creators. We were enthralled, Madam, on that event, that day, 60 years of Parliament, how Santur was played by Shiv Kumar Sharma, how Shubha Mudgal enthralled us by her vocal performance. These are people who keep up our traditions. These are people who are able to tell the rest of the world the enormous wealth of Indian culture. And I'm sorry to say that whereas we treat them with great respect, the industry which uses them shows an enormous amount of disrespect by taking all their rights away. So I think that a time has come when we all, the House, should speak in one voice to correct this historic injustice. And this is the first amendment, because there are about 7 amendments, because I'm not going to deal with each section. But broadly, one of the things that we wish to do is to ensure that the authors are the owners of the copyright. And whereas the copyright can be assigned, the right to royalty cannot be assigned. This is the amendment that we are moving, that you can get the assignment from the artist, whether it's a music composer or a literary composer, you can get the assignment of his right. But when it comes to payment of royalty through other mediums, then the producers and the authors must share that royalty in equal measure. So this is the first amendment that I've brought, that I'm commending to this House for adoption. We have also consequentially brought about changes in the copyright societies. Because in the copyright societies, all the producers control the copyright societies, because the provision said the owner of the copyright shall be in the management of the society. And because of 17(1)(b), the owner of the copyright became the producer. So the authors were thrown out of the copyright societies. Only the producers became owners of the copyright societies. They decided to negotiate with music companies. They decided to sell those works, especially Hindi songs, which are famous throughout the world, to music companies, made a killing on them, and the poor artist was left in the lurch. I remember it was a very sad day when Bismillah Khan came to me and he said he does not have money to pay his rent. And I cut a check for him for 1 whole year, so that he could pay his rent. It was a very sad day for me, because here was a man who held up the most precious traditions of our culture, and he was on the street. I have known of artists, people like Ravi, who would not pay their hospital bills because the producers would not part with their royalty. And there are other instances, and I don't want to go into these questions. The fact of the matter is that the time has come, and all over the world there is equitable distribution of royalties. But unfortunately, this is not what has been happening in India. I wanted to give this right to the principal director of film as well. Madam, ultimately, in a film, who are the real artists? Those who sing the songs, those who perform, those who direct the film. Now, a director is kept out of any profits of the film. He is the one who actually creates the architecture of the film. But unfortunately, he doesn't share in any part of the royalty, because there is no risk capital involved. It's the producer who risks his capital. And though I made this recommendation to the standing committee that the principal director should also partake of the profit, the standing committee had thought in its wisdom that the time has not come for the principal director to be included and he too share in the profit of the business. So I have in fact dropped those amendments and I have not pressed on them. The other issue, the second issue that I want to raise before the distinguished members of this House is that through technology and through the advancement of technology, now we can empower the visually impaired. What happens is that if a visually impaired wants to get access to copyrighted material, the unamended law did not allow him to do so. He would have to pay for it. How many visually impaired people in this country have the capacity and the wherewithal to pay for copyrighted material? So we thought in government that it was time for us to ensure that those visually impaired people who want access to copyright in any form, in any format, must be given access without payment of any charge. And we've brought about that amendment to the bill, and we have added section 52(1)(zb), and I just want to indicate to you what it says. The adaptation reproduction, issue of copies or communication to the public of any work in any accessible format by any person to facilitate persons with disability to access to works, including sharing with any person with disability of such accessible format for private or personal use, educational purpose or research, or any organization working for the benefit of the persons with disabilities, in case the normal format prevents the enjoyment of such works by such persons, provided that the copies of works in such accessible format are made available to the persons with disabilities on a non-profit basis, but to recover only the cost of production. Provided further that the organization shall ensure that the copies of works in such accessible format are used only by persons with disabilities and takes reasonable steps to prevent its entry into ordinary channels of business. So all these activities now are free of charge, and the visually impaired and persons with disabilities will have access to any kinds of, all forms of format. But for those who want to make profit and still supply those formats to disabled people, they will also be entitled to, but of course they will have to pay a bit of the royalty as decided by the Copyright Board. So those are the second set of amendments that I am bringing for commendation of this House. The third, Madam, is that it's a very curious thing that whereas in the past, orphaned works, a person who had died, there was no heir, there was a copyright, and nobody knew as to how to get that work published. So the original Act had a provision that these orphaned works could well be published after a compulsory license is taken. But there are several unpublished works that are unpublished for which there is no author who is willing to claim title to those unpublished works. And there was no provision in the Copyright Act to get access to those unpublished works. So the third set of amendments that I am commending to this House is to ensure that any person who can get access to an unpublished work of which there is no claimant can actually go to the Copyright Board, and we can then get unpublished works published through a compulsory license, which will give access to thousands and thousands of readers and consumers in this country. That's the third set of amendments that I am commending to this House. The fourth is with respect to cover versions, which is incorporated in Section 31C. What used to happen in the past is very interesting, and I as a lawyer have argued several cases on it. What used to happen was that if you had a song, immediately some company would get another singer to sing that song, right? So what they would do is they would have a cover which would indicate that this is the song. It would be sung by somebody else. The packaging would be done in such a nice manner, and the price of it would be more than the original song. So people made a lot of money on it, and they would do it immediately after the song came to the market. So therefore, in other words, they were exploiting somebody else's copyright. So we needed to bring those amendments also into this Act. Now we say that you can't exploit any such work till 5 years have elapsed from the time that the song was first released, so that nobody can take advantage of the copyright in this fashion. And there are several restrictions that we have now incorporated in the cover versions as well, because the cover versions should not in any way mislead or confuse the public. So these I don't want to go into those details. Yes, 5 years at the moment. So this is now a statutory license regarding cover versions, which is reflected in 31C. The compulsory license is reflected in 31A, which is also a new section. And there is another statutory license under 31D. This was again a matter of great debate. Matter what happens to radio companies and broadcasters is the following: that especially small radio companies, with not much investment, their only source of revenue are the songs. And therefore, there is no other source of revenue. TV, of course, have different sources of revenue. You have Antakshari, you have Kaun Banega Crorepati, you have cricket, you have all other sources of revenue. And there was a demand that broadcasters together should be subjected to a statutory license. In other words, that there will be no negotiation. The Copyright Board, as a matter of law, under the statute, will actually decide on the quantum of money that will be required to be paid by the music companies to the TV companies, or by the TV companies to the music companies who have bought over those rights. And therefore, there was some debate as to whether it should be limited only to radio and TV should be kept out of it. But ultimately, we decided that TVs would be included in it. So broadcasters in general are now subjected to statutory rights. And therefore, the Copyright Board will alone have the jurisdiction to decide the quantum of monies that will have to be paid by broadcasters to owners of the music, which of course in turn will include both the producers and the authors in different forms, and they will share in the profits. So that's reflected in Section 31D of the amendment. Then, Madam, the other thing that I just wish to mention to you is that globally now we have a couple of international conventions and international treaties. The first of its kind was the Berne Convention way back in 1886. But we have some new international conventions and treaties that we need to adhere to. One particular treaty is the World Intellectual Property Organization, WIPO, Internet treaties, namely WIPO Copyright Treaty. It's called the WCT. And the other is the WIPO Performances and Phonograms Treaty, called the WPPT. Now, these two treaties extend the protection of authors and right owners in the digital environment. Madam, as you know, the digital environment is going to be the future of the world. It's in the digital environment that access to music and access to all forms of copyright will be made. And performers also are entitled, not just music directors, not just literary persons, persons who create literary works, but also performers on a stage. For example, persons who performed on the other day on the stage, that performance itself can be subject to copyright, because performers too should have certain rights. Now, these treaties have not yet been ratified by the Government of India, but we wanted to make sure that we are in sync with the essence of those treaties, with the intent behind those treaties. So we have, through Section 38A, given exclusive rights to performers. That is an exclusive right to an actor, a singer, a musician, a dancer, a pantomime artist, a magician, a conjurer, a snake charmer, and any other person who performs. All of them are doing creative work. And if they are doing creative work, they are entitled to copyright protection. And if anybody uses their performance for the purposes of making money, then royalties must be paid to the original performer. And therefore, we have included in Section 38 protection, exclusive protection to such performers and copyright to their performers. And all the rights that are available to authors and others will equally be available to these performers. We have also included another very important provision, which is 38B, which are moral rights. This is again consistent with the convention with the treaties that I was talking about, and these moral rights, according to me, are also extremely important rights, and I'll just indicate to you. (38B) reflects those moral rights. The performer of a performance shall, independently of his right after assignment, either wholly or partially of his right, have the right to claim to be identified as the performer of his performances, except where omission is dictated by the manner of the use of performance. To restrain or claim damages in respect of any distortion, mutilation, or other modification of his performance that would be prejudicial to his reputation. What happens is that if a commercial enterprise gets hold of the performance, they will edit it in such a way, put other things into the performance to change the nature of the performance, and that make money on it. Now we have said that no, performers must have moral rights. They are entitled to sue those persons if they mutilate the nature of the performance, change it for the purposes of making money, and therefore those moral rights are also now incorporated in this Copyright Act. This was the fifth issue that I wanted to commend to distinguished members of this House. The sixth is, of course, exceptions and limitations to copyright. Madam, all rights must have limitations. That's underlying every right in the Constitution of India, whether it's freedom of speech, or freedom of expression, or freedom to move anywhere in the territory of India, or freedom to do trade, or freedom to form associations. Every right must have a concomitant obligation and restriction. So even these rights must have restrictions. And what are those restrictions? If a student wants to do research in copyrighted material, he cannot be charged. If somebody wants to do research in copyrighted material or wants to teach something, it cannot be charged. If I want to use it in a debate in this House, copyrighted material, I cannot be charged for it. If I want to use it in a judicial proceeding, I cannot be charged for it. And therefore, naturally, it's necessary to have those restrictions. And sometimes it so happens that because of modern technology, a copyrighted material comes to an internet service provider. He keeps it for 15 seconds and then gives it to the person who asks for it. Now, that transient period is not an infringement of a copyright, because the internet service provider is using it only as a means of communication to the person who is seeking access to that copyright. And therefore, to that extent also, this is something. And then, of course, some of these things can be used in current affairs. Because if an issue comes up in the context of current affairs, a debate comes up in Parliament, is reflected in the House, and in that context some copyrighted material is used in the course of that debate, surely the person concerned who uses that material should not be charged with it. And of course, non-profit libraries. Many of this copyrighted material can be used and should be used and must be used in non-profit libraries. That then is the other exception that he has provided. But all these I have given broad indications of the nature of these exceptions. All these exceptions are set out in section 52 of the Act, which we have amended. And the last, this is item 6, and the last one is the amendment which is reflected in section 65A and 65B. These amendments are also necessary because we believe that there is a lot of piracy that is happening through technology in this country. A lot of piracy is taking place. People are using technology to take away somebody's copyright and then use that material. And we think the time has come to deal with piracy. And therefore, we have incorporated section 65A, which says any person who circumvents an effective technological measure applied for the purpose of protecting any of the rights conferred by this Act with the intention of infringing such rights shall be punishable with imprisonment, which may extend to 2 years, and shall also be liable to fine. Similarly, in section 65B, any person who knowingly removes or alters any rights management information without authority, or distributes, imports for distribution, broadcasts or communicates to the public without authority copies of any work or performance, knowing that electronic rights management information has been removed or altered without authority, shall be punishable with imprisonment, which may extend to 2 years, and shall also be liable to fine. These then broadly are the nature of the amendments that I commend to distinguished members of this House. I want to, at the end, say only this, that technology has changed the way we live. Technology will also change the way we entertain ourselves, and technology will change the way others will entertain us. And I think we need to embrace this technology, amend our acts to bring in, to ensure that we have brought it in conformity with the needs, modern needs of society, which our children are going to access in the future. Thank you very much, Madam. I commend these amendments to the members of this House.